This is a 1-hour training, and my name is Jean Fettner. I am the manager of the training team for OCHN. I just have two quick announcements before I turn it over to the speaker. The first announcement is that this training is being recorded. So that will include any questions and any responses to those questions. I just want everybody to know that. The second thing is that we have one social work CE approved for this training, and those certificates will be issued within 1 week of us receiving a evaluation back from you, evaluation of the training. So that will be handled at the very end of the training. You'll be given a link to the eval. And once we get that back, we will initiate a CE certificate. The rest of you will get an attendance certificate. So with that said, I want to turn this over to Megan, who's going to get us started. Thank you, Megan.
Thank you. Good morning, everybody. Welcome to Mental Health Petitions, How to Complete and Other Questions Answered. So we have a couple of presenters today. We have Barb Andruccioli, who is the probate court register. We have Mac Holman, who is the court liaison with Common Ground. And I am Megan Hebert, the Assisted Outpatient Treatment Coordinator with Oakland Community Health Network. Our learning objectives for today, we're hoping that all of you, when you walk away from today, will be able to identify individuals who may need to be petitioned, and also just in general, being able to complete the mental health petition process. All materials that we use in this training and presentation will be sent to you guys at a later date. So the PowerPoint and some of the forms that we're going to put in the chat too. We do ask that if you guys have any questions, please put them in the chat. We'll be monitoring it. And then we will go ahead, and there's time at the end for a Q&A, and we'll go ahead and answer them at that point. So before we get started, I'll talk just a little bit about Oakland Community Health Network for those who are not aware of who we are. We are a community-based local public mental health system that manages specialty support and services to individuals who suffer with mental health issues, serious emotional disturbances, intellectual or developmental disabilities, infant mental health, and substance use disorders. Our mission statement is to inspire hope, empower people, and strengthen communities. In fiscal year 23, we were able to provide services to 29,000 people here within Oakland County. OCHN does have an access screening process, which determines where people's needs are best met based on their severity and urgency. Screenings can be requested by calling the number on the screen or by visiting the Resource and Crisis Center. Walk-in appointments are received on a first-come, first-served basis. And I will go ahead and hand the presentation over to Mac. Just let me know when you want me to change slides. Okay, Mac?
Okay, thank you. Can everyone hear me okay? All righty. Our Michigan Mental Health Code defines a person who has a mental illness and requiring treatment, and it does mention here, or a minor requiring treatment. For our purposes, we're going to be focusing on adults requiring treatment. Mental illness is by law a substantial disorder of thought or mood that significantly impairs judgment, behavior, capacity to recognize reality, or ability to cope with the ordinary demands of life. So in other words, serious problems living, what we consider a normal life. What we're looking for when we say a person requiring treatment first must have a mental illness, and we define that as may intentionally or unintentionally physically injure themselves or another individual, or has made significant threats to do so. We often say that the person is homicidal or is suicidal. They don't literally have to be homicidal or suicidal, but there has to be some reasonable expectation that they could cause harm to themselves or to someone else. And that can include not attending to their basic physical needs, such as food, clothing, or shelter. We would also look at a person's judgment. Is it so impaired that they are unwilling to voluntarily participate in treatment, or that they're, unable to recognize the fact that they need treatment? The bottom line in all of these, as you can see, is that there has to be some expectation of harm either to themselves or others. And then you can see in the slide there that we make exception that an adult who has, let's say, dementia, epilepsy, alcoholism, or other drug dependence is not necessarily a person that we define as requiring treatment, but they would also need to meet one of those other three conditions shown above there, and you can change the slide. There are basically three ways to get a person examined if you believe that they are a person meeting these criteria. They may be willing to go voluntarily, and we'll talk more about what that means. You may have to get the assistance of a peace officer, and we'll talk more about that in just a minute. Or you may have to go to the probate court at 1200 North Telegraph, Mental Health Division, and ask them to get you an order for this person to be examined. Barb, I just had a quick question here. If they do that, I know they have to go through security and there's a metal detector. Are cell phones allowed in the courthouse now?
Yes, they've changed the law. Cell phones can come into the building.
Okay. It used to be they would send you back to your car. Okay, so thank you for that. Thank you. When we say voluntary and involuntary, what we really mean is what kind of paperwork is being done. There is something called an informal voluntary basis, which I don't know how often that actually happens, but basically a person asks to be admitted. The hospital says that's okay. The person can basically leave when they want to. With a formal voluntary, though, a person has to sign a document that says that they are signing themselves into the hospital. If they then wish to sign themselves out, the hospital has up to 72 hours to hold them and evaluate them and say, yes, you can go, or no, you can't. And then we would start the involuntary process. The slide there says if a court petition is filed, but the individual then signs voluntary, the petition is dismissed. Yeah, I know that's what's supposed to happen. I see sometimes it doesn't always. In any event, the individual should remain hospitalized until they are clinically suitable for discharge. Sometimes, yeah, I'll get to that in just a second. Sometimes we see people who think that they are voluntary because they came willingly. But again, it's when we say voluntary or involuntary, we're talking about what paperwork was done. You may find that you can't get a person to go to the hospital voluntarily, so you're going to need some help. And you can go over to peace officer now. Thank you. If you can get a peace officer to observe a person acting in such a way that that peace officer believes that this is a person with a mental illness and requiring treatment, as we discussed before, the peace officer can take that person into protective custody, which is different than being under arrest, and transport that person to a pre-admission screening unit for mental health services. In Oakland County, that's common ground. However, we sometimes find that police officers and ambulance crew will take them to the nearest emergency room, which makes a certain amount of sense too. A peace officer who acts in compliance with this section of the mental health code is not civilly liable for any action. Let's say that person takes offense to being hospitalized. Peace officer's doing his job or her job. It's all okay. If you cannot get a peace officer to take the person to the probate court, you may have to go to the hospital or to common ground. You may have to go to the Oakland County Probate Court and fill out a petition. And we're going to look at that petition in just a minute. but you're going to fill out the petition explaining why you believe this person is a person with a mental illness and who requires treatment. And Barb, take it away.
Thank you. Next slide, please. I know it says we're going to look at the form. We're actually going to look at that, like Max said, in a minute. Petitions, as Max said, are filed at the courthouse. We're located at 1200 North Telegraph Road. We're actually in the same campus as Common Ground. We're just kind of across the parking lot from them. Any individual that's 18 years or older can file a petition for someone they believe requires mental health treatment. Most times it's a family member, like Mac was talking about, a police officer if they've observed a behavior, or a hospital itself. They're the usual petitioners on the petitions. To be able to file a petition in our county, they must either be a resident or currently found in our county. We do have people that say their behavior has a police officer bringing them into a hospital and they don't live here. They may be in Genesee or somewhere else, but they're currently down here, so they bring them to a local hospital. Our court could then hear that case. So it's either they live in Oakland County or they're currently in our county. Before a hearing can be held, there has to be a clinical certificate from either a physician, psychiatrist, or a licensed psychologist who has examined the person. If, like Mac was talking about, if you can't get a clinical certificate because they won't agree to be evaluated, you can come to the court and file a petition for a transport. There's a hearing held in front of a judge or myself or the administrator. And we take testimony as to what the person has done to get an evaluation and if the behavior is warranting them being able to be transported to be evaluated at Common Ground. As Max said, the police officer isn't civilly liable. There are some gross negligent exceptions, but that's definitely the exception if something is very extremely done during the transport. They aren't under arrest. They're just being transported for an evaluation. The petitions can be brought to the court in person. Like Max said, you can walk in, you can bring your phone in. We're on the first floor of the courthouse, not the ground floor, but the first floor, and there's a mental health division. You would go there to get the petition. If you have, we have petitions on our website, so they can also be faxed in and they can be emailed in. And that's the fax number. The email address is probatecourt@oakgov.com. So there's 3 ways to get the petitions here. Next slide, please. This is actually the petition. This is in blank. We're going to go over it later on. We're going to go on to it as a sample so you can see exactly where some things are filled out. But this is that's what the petition looks like. This is basically a new form since 2020. It's a protected personal information form. When we go through the petition, you'll see there's an area that says on the date of birth, you must fill out this form because you can no longer put a date of birth on the petition because it's protected information. Date of birth, social security number, driver's license number. All those that would go on this form. This is actually a universal form for all the courts. So circuit court, family court, probate court, we all use the same form. So that's why there's information like financial stuff. That stuff wouldn't apply to a mental health petition. It's just that the form is a generic form and it's used for all kind of protected information. Right. This is the order for transport. So on the petition, like I said, when we look farther down, it's number 8. That's where you're going to be asking for someone or a police officer to transfer the person to the examination. And then also, as Max said, it's supposed to statutorily go to Common Ground, our screening unit. It can go to hospitals also. That does happen quite often. Like I said, once again, they're not under arrest. The officer takes them into protective custody. So actually what that means is the officers usually like someone to be at the home so they can let them into the home because they can't break down a door. If someone was threatening homicide, suicide, or if they had probable cause, they could then enter. But most times if it's just with a petition, they can't like take the person by force. They try to get them to go along as peacefully as they can into protective custody to get the evaluation. Next slide. Oh, thanks. After the hearing, if the request is granted, because what happens is they come to the court, we have testimony, they get the order signed that time, that instant, they go back to the counter, the mental health counter, and they get a seal because the police want to see the court seal. So once it's granted and they have the seal, they can bring that certified order then to the local police department. So we would go to the police department of where the person was residing. The order is good for 10 days. If for some reason they can't execute it, say they're, the people aren't at home anymore, or they won't let them in, the order just expires. The police are supposed to let us know if they're unable to execute the transport order, but the person themselves can actually just come back in after 10 days and get another order. It just expires. That's an order for transport. I know it's probably difficult to see. Under the it is ordered part, number 6, that's where it would say going to common ground. And on the second page where it says report of non-execution, that would be what the police would send back to the court if they're unable to execute the transport order. And back to Mac.
All right. I think every state now has an assisted outpatient treatment law, and they vary state by state. And you may find that the way they're executed may even vary county by county within a state. We used to call our law Kevin's Law. You may still hear that name. I won't correct you if you use it. Kevin, as you see there, was a young man, a University of Michigan student. He was either on his way home from school or going back to school when he was accosted by an individual with a mental illness, being untreated, I've been told. Kevin eventually died of his injuries, and his family was instrumental in getting an AOT order enacted here in Michigan, and we've had it for about 10 years now. What it does, it is an outpatient order that says that a person is expected to comply with their outpatient treatment, and there will typically be some description in the order of what that treatment includes. It typically includes medication management, which the way we word it in Oakland County generally says may include injectable medication. And it will typically include case management. It can also include things like assertive community treatment, supervised living, substance abuse services, individual or group therapy. The advantage of having a Kevin's Law order over, there's a question, what is Kevin's Law called now? We just call it AOT, or assisted outpatient treatment, but you can still call it Kevin's Law. I think most people still know what you mean. The advantage to having an AOT order is when a person is refusing treatment and perhaps starting to decompensate, it gives you an avenue to intervene now rather than wait to the point that they would be petitionable, by which time something that we don't want may have already happened. To get a person on a Kevin's Law order, there are 2 ways, and I'm going to tell you the outpatient way first and then the inpatient way briefly. Let's say you're a case manager or a concerned family member. You would go to the Oakland County Probate Court Mental Health Division. You would fill out the petition that we showed earlier. You would check 3C and 9C. And you would explain, why you believe this is a person who needs this order. The court will set up a hearing to take place within 28 days. It says there if the petition was filed while they were hospitalized, then the hearing will be held in 12 days. Usually in that case, what we're looking at is a hearing for hospitalization, and typically a Kevin's Law order will come with that. The court will expect a psychiatrist who has evaluated the person to be able to testify at the hearing. If a psychiatrist co-signs the petition, then a psychologist or another physician who has also evaluated the person may then testify in the psychiatrist's stead. If you have a clinical certificate, then you can check one of those two boxes. It's my understanding, Barb, that if a clinical certificate is included, then that psychiatrist will be expected to testify?
Yes.
Okay. If no clinical certificate is attached, that's fine, but we will still need a psychiatrist to testify down the road. Turn it over. With court hearings, let's say that a person is hospitalized with a petition and a physician certificate. Common ground, well, every county is required to have some kind of a community mental health board. Some counties share a community mental health board. Oakland County has its own. And in Oakland County, the ROCHN has decided that Common Ground will do the alternative treatment report. The alternative treatment report is a report that's made when a person is hospitalized involuntarily. And this is supposed to be community mental health's recommendation of what should be done with this person, what services would be available on an outpatient basis, either now or following hospitalization. Generally, I find that if a person is in a hospital involuntarily and has already been there a few days and we're now going to court, more often than not, there's a pretty good reason for that. When I do an alternative report, I will look at several things. I will, if possible, interview the person. I'll confer with hospital staff. I'll confer with case managers. I'll confer with family, legal guardians, and I will reference our OCHN records. I'm not sure that we got a copy of the ATR form, did we?
We did not.
Okay, all right. We can probably get along without it. Okay, already did that page. I think we're back to you, Barb.
Okay, I'm going to talk next about court hearings. Under the mental health code, when someone files a petition, we got the clinical certs. We decided that the person needs to be hospitalized. The individual still retains all their rights. They have the right to an attorney. They have a right to have witnesses. They have a right to an independent evaluation. They're required to have 2 certifications for the hearing to take place. But the individual can still say, no, I want my own evaluator. So they're entitled to have that before a hearing is held. They're also entitled to a jury trial. But there's a couple conditions for a jury trial. They have to do it in writing, it has to be a written demand, and they have to request it before the first witness testifies. That's really important because once the first witness testifies, they forfeit the right. They can't ask for a jury trial then. It'll just proceed in front of the judge. If they do ask for a jury trial, it would be adjourned for good cause. Normally, I think we might have just kind of covered this kind of quickly. If someone's in a hospital and a petition for mental health treatment is filed, we're required by law to have their hearing within 7 days. As you know, in court, things usually aren't that quick. They don't usually happen in 7 days, but under the mental health code, it's required. So the hearing has to be held within 7 days. If someone's having assisted outpatient treatment because they're not in a hospital, we can do it within 28 days. But other than that, if they're in a hospital, it has to be held within 7 days. If they request a jury trial, there's really no way a jury can be assembled in that short of a time. So that's why they will allow it to be adjourned out and the continuance, that would be considered good cause. If there is a jury, the verdict has to be unanimous. I'm sorry, next slide. Thanks. The hearing is conducted like any other trial. There's opening statements, there's witnesses presented. The person can testify themselves. They don't have to if they don't want to. The court has to find by clear and convincing evidence. So it's not beyond a reasonable doubt standard, which is the highest standard, that's criminal. But by clear and convincing evidence that the person is a person requiring treatment. If the judge, or if there's a jury trial, a jury decides after the hearing that the person isn't a person requiring treatment. They very well may have a mental illness, but they may not hit one of those three requirements that Mac had discussed earlier. Basic needs, homicidal, suicidal, or a danger, or have impaired judgment. If they don't found that to be the case, that person, if they're in the hospital, there will be immediately discharged. If they don't find that they're a person requiring treatment. However, if the court does find that they, by clear and convincing evidence, that they require treatment, the judge has three options. They can order straight hospitalization only, assisted outpatient treatment only, or a combination of the two of them. On an initial or first order, if they're going to order only hospitalization, they can't exceed 60 days in the hospital. If they're ordering assisted outpatient treatment only, they can only order up to 6 months. That's the maximum on this order, the 6-month order, 180 days. If they order a combination, which most petitions that I see come through, that's what they order as a combination. They can order up to 60 days in the hospital, and then the rest of the 6 months would be assisted outpatient treatment. Next slide. That's what the initial order looks like. Mac had mentioned that a little bit before he was kind of going through some of the things. I was just going to point out real quick on this. Number 5 is who testifies. So you're going to have a doctor testifying. If the ward testifies, sometimes it says there's the person's testifying that the person refused to come to their hearing. They have the right to do that. If they refuse to come, it'll be the person who said why they weren't able to attend. That will be on who testifies. Under number 6, it's one of those three things. So those are the three things that Mac had highlighted before. The first one is a danger to themselves or others. The second one is unable to take care of their basic needs. And the third one is impaired judgment. And on the second side, if there's a treating agency already involved, like Easter Seals, TTI, CNS, that's who they'd be assisted by. This is for the assisted outpatient treatment part. So I would say either community mental health and or like common or CNS or TTI. And then those are all the services that the court will enter. And they kind of just go down a list. It's case management, therapy, medication, injectables. So based on what MAC recommends and what the doctor recommends, the judge will order those things for the mental health plan. Most commonly we see here, mostly it's case management, medication, injectables, and therapy. Those are kind of the most common things that are ordered. And that's just the last page of the order, and that's where the judge signs it on that page. Court orders assisted outpatient treatment. So that was for the initial order. Unfortunately, some people, they go in and they have an initial order. They get their medication, they get stabilized, they do well, and they may never come back to court again. But unfortunately, we have some people that either they spiral and it's kind of a cycle, or they just kind of need additional treatment. So after the initial order is a 6-month order, like I said. If they find after 6 months the individual still needs involuntary mental health treatment, they can file a second order, a petition for a second order for mental health treatment. If that is granted, the treatment can last up to 90 days, and that's either inpatient or outpatient. It's only a 90-day order. If at the end of the second order, they still need treatment, They can file a petition for continuing treatment. And that's actually a 1-year order. The treatment can last up to a year in or outpatient. Unfortunately, we have some people that have been on continuing orders for years. They just aren't able to, it doesn't seem like they're able to function outside of a hospital, and they may be for a very long time. I think when there were a lot more hospitals in Michigan, there were probably a lot more people in continuing orders. So that is an option. The only main requirement about that, if you need to have the person continue with treatment, it's really important that you file your second order or your continuing order at least 14 days before the prior order expires. If they miss that deadline, you have to start from the beginning and file an initial order. So it has to be filed before the 14 days at minimum before the prior order expires. That's actually just a petition for second. That's what it looks like. It's basically the same information. It's just the time limit is different. The 90 a day. And then this is the continuing. That's the one that's up to a year. If someone is found to need involuntary hospitalization, either just hospitalization or a combination of assisted outpatient treatment and hospitalization, their name immediately goes into lien as soon as we have the order. And what the lien system is, exactly what that is, the Law Enforcement Information Network. That's a Michigan State Police firearms record unit. It goes to them basically to prohibit the purchase of a firearm. That's what it's for. So as soon as someone either hospitalized or a combination of assisted outpatient and hospitalized, they immediately go into lien. If they're only under an assisted outpatient treatment order, they do not go into lien. There has to be hospitalization to go into the lien system. Under a regular guardianship, that also works for someone's under guardianship, they go into the lien system also. However, if they are then restored, if the guardianship is discontinued, they immediately come out of the lien system. When you're under a mental health lien, that's not the case. You can only by a subsequent court order be removed from the lien system. You'd have to file a petition and have usually a doctor's letter or a doctor's report or a doctor testifying that they think that you can come out of the lien system.
Barb, when if I can interrupt, does being on, let's say I get a court order, a treatment order, and that goes into lien, does that just prevent me from buying a firearm, or does it do anything else?
As far as I know, it just prevents you from buying a firearm. I think you're just kind of on a list. So I don't know if that list is given to other kinds of law enforcement or any other. I mean, I have police and FBI people calling sometimes to see if somebody's in our system, even though they have an order on them already. So I don't know. It seems like it's kind of a little more far-reaching than just that. But to be honest with you, I'm not exactly sure. I just know that it goes to the firearms record unit.
Okay, thank you.
Sure. Next slide. Megan, I'm sorry, next slide.
Well, you want this slide, correct?
No, the next one.
This one.
Nope, the next slide. We did the lien.
So I apologize. The next slide after lien is just the sample petition.
Correct.
Is that what you guys are seeing?
No. We still
That's
see
what
the
I
lien
see.
slide. Oh, you do see it? I just see the lien. I'm sorry.
Oh,
Okay. If you guys are seeing it, I have my paper one. Yeah, I'm only seeing the lien still.
Sorry about that. That was probably the issue. But yeah, it should be up.
Okay, I did it manually myself, so that we're good. I'm sorry about that. This is actually a sample form, and when you get your PowerPoint, you'll be able to see it a little better because I'm sure it's really difficult to read. But basically, it's all made up information. But just so you know, on number 2, That's what the court looks for. That's where they're residing. So they either have to be found in Michigan, I'm sorry, in Oakland County, or residing in Oakland County. So that's where that would be now. So we look to make sure they're in the right court. Under number 3, that's where it talks about the 3 qualifications for someone requiring treatment. You would check one of those. You can check all 3, which is very often what happens. You know, their judgment is impaired. They need help with their basic needs, and they don't. They're either a danger to themselves or others. Number 4 is really what we really hope that who's ever filling out the petition pays attention really to number 4, A and B. Number 4 is the petitioner's personal observations, what they've actually witnessed and saw that makes them concerned. That's why they came to court. Why they think the person needs to have mental health treatment. So as specific as you can get. I realize there's only a line filled out there, but it's just whatever you think will help a judge determine this person needs mental health treatment. On the B part of that, that is things that you might have heard from friends and family that you can also complete on the petition. So as much detail as you can give. If you need more space, you're welcome to add another page to it. So as much detail you can give, because this is also sent over to Common Ground. So they see the petition and know what's been filed with the court. Number 5, that's just the family, spouse, children, and if they have a legal guardian, their name and address should be put in there. Number 8 is the transport part. You know, if you need a police officer to help transport the person for an evaluation. Number 9, as Mac was saying, for assisted outpatient treatment, you would do 9C. That's assisted outpatient treatment only. That's without hospitalization. A and B are hospitalization only or a combination. We most often see a combination checked because people really don't know if the person needs to be hospitalized or not. So they usually do a combination to basically get them whatever help they're going to need. If the person has an attorney, they would sign on the left side most of the time. 99% of the time, they don't have an attorney. They're doing it on their own. And on the right side would be the petitioner's information. It's real important that all the boxes are completed to the best of your knowledge. Give as much detail as you can. And then, like I said, on it's basically right under number 1. I'm sorry, it's right under the name. The second box in says date of birth, and right in there it says that you have to use that second form.
Mm-hmm.
You can't put the date of birth on the petition itself. That's going to go on the personal protective form.
Excuse me.
So Barb, I don't know if you can see
Mhm.
it. That's the example
Yeah.
that we filled out. If you can see
Yes.
it, the next slide. Okay.
Mm-hmm.
Oh, okay, yes. And I see. There you go. You know what? I'm just going to do it manually because I can move them. That's okay. But yeah, you probably still need to do it too for everybody else. But yeah, that's the protected personal information form. Most of the time, we just have the date of birth, and that's really important because we need that for the lien. The police can't take the order without their date of birth because obviously there's people that have the same name. So the date of birth is really important in there. The other information like driver's license or social, if you have it, that's great. Banking information, you're never going to have. Like I said, this is kind of a universal form, so you wouldn't need that at all. And I think we're to frequently asked questions. I think we're just going to read these couple and then ask for any questions that you might have. Frequently asked questions, where are petitions filed? They're filed here at the courthouse. This is the big white building in Pontiac, the 1200 building, big marble building. It's pretty hard to miss. Like I said, we're on the first floor, not the ground floor, but the first floor. We have 2 divisions, the probate counter, which is guardianships and conservatorships and estates. And then we have a mental health division that's on its own room. You would go to the mental health division. That's where you would find it. And that's where you can get the petitions. That's where you can get a transport petition. And then you would have a hearing here in the court.
If you
What are the costs?
Go
I'm
ahead.
sorry.
No,
I was just going to say the costs are, there's no.
Yeah.
I'm sorry, Mac. I was just going to say there's no filing fees. There's no cost to file the petitions.
If you go into the building on the side with the TV trucks, that's the ground floor.
We have lots of them today. So Did you want to do the second two, Mac?
Okay, well, what do we got? There are no costs. Can a hospital discharge someone prior to the hearing? Absolutely. The hospital is always free to hospital or discharge anyone as they see fit. Do they in fact notify the court in writing? Barb?
They're supposed to. Sometimes we
Mhm.
get it after the hearing is scheduled, but
Mhm.
they're supposed to.
Okay. When the hearing comes to be, the court will either dismiss the petition or hold the hearing, depending on the circumstances. I presume they will hold the hearing if the person is still there and the hospital has not retracted their petition.
Yes.
If a request for transport is granted, will the individual be hospitalized? Not necessarily. The order for transport only means that the police must make a good faith effort to locate and bring the person to a place, presumably common ground, but it could be a hospital emergency room, where they can be evaluated to see if they need hospitalization. If it is felt that they need hospitalization, then yes, they will be hospitalized. If it is not felt that they need hospitalization, they will be released.
Thank you. So there are a couple of questions that are in the chat. The first one is, if a person is hospitalized for attempted suicide with the use of a firearm, will they go on lien or into the lien system?
They wouldn't go into lien until there's a court order. So just because they're hospitalized doesn't put them into lien. There has to be a court order for the lien to take effect.
So a person could sign voluntarily into the hospital, or they could defer their court hearing and agree to treatment. And even though there was a firearm involved, they would not go into lien.
Correct.
Okay, thank you. We have another question. Can an individual who is hospitalized defer their hearing and still be discharged from a hospital? If so, what is in place to ensure that they will adhere to the conditions of AOT in the community?
I get this
That's
question a lot.
That's a great question.
Okay. If they defer, then depending on how the deferral is written, it should include that they're agreeing to hospitalization and outpatient treatment, or at least one or the other. Let's assume that it includes outpatient treatment. And there should be something in there about where this outpatient treatment is going to be and what kind of treatment it is. You know, medication management, case management, the things that we talked about before. That deferral doesn't just disappear once the person is released. It's still good for the length of the deferment period, which is probably 180 days if it's for a combination order. And in that time, let's say after 30 days, Joey doesn't want to keep going to Easter seals and he's not taking his medication and we're worried about him. Easter seals can then go back to the probate court and file a notice of non-compliance. Well, actually, I think in this case, they would file a demand for hearing.
Right.
And then a hearing would be convened and the person may be put under an outpatient order.
Unfortunately, we don't get very many of those when they're still under the order. We end up getting them when, they'll come back, the parents will come back 2 years later and say, he's refused to go to Easter seals for the last 3 years. And there's not a lot of immediate, because the statute says shall immediately notify the court if they're not compliant. And it doesn't happen very often, unfortunately. I've been here 5 years at the court. I'll bet we've had 20 in 5 years. So it just doesn't happen. And unfortunately, and then it seems to be, I have the crisis and then they have to start all over again with an initial petition.
I think part of the problem is that there isn't real good communication between the hospitals and CMH providers a lot of times. So case managers who may not be that familiar with the process in the first place, don't know that the person has signed a deferment and don't know that they have this option of going back to probate if the person isn't playing ball.
I agree.
And if I can add, so unfortunately, we have a process here within Oakland County, not a program, but we are part of my position is recognizing the gaps in our system. And I have been able to connect with some of the hospitals to try and figure out a process for, dealing with these deferment hearings. Unfortunately, I'm only one person. So we are in communication. We are hoping to have some changes in the near future. So hopefully with time, we will see some improvements here within Oakland County, but we are very aware of the gaps. And we're starting slow, but we're trying to do what we can. And hopefully with, some potential grant funding, maybe some opportunities will open up.
Right.
Okay, great. Thank you so much. That's good information. Our next question is, if a person is hospitalized for court-ordered treatment, are they financially responsible for the treatment?
No. Not that I've ever heard. I've never heard of anybody getting a bill. I don't believe they are.
It's always been my understanding that it's conceivable that you could, but yeah, I've never heard of it happening either.
Okay, what is the process for after hours?
Meaning,
Like you have a person who's in crisis and you can't wait till the court opens in the morning?
That's what I believe. Crystal, if you would like to unmute and explain your question, but if they have it, that's fine.
Yes, that's the question, because a lot of times, for whatever reason, Fridays at 4 o'clock or 4:30 is when we
Story
experience
of my
what we
life.
do.
yes.
I don't answer my phone after 4 o'clock on Friday.
Yeah. Unfortunately, there really is, I would say you'd have to call 911 if someone's in a real crisis, because there is no judge like on call to be able to do anything after hours. So it would have to end up being
Okay.
a 911 call.
And then you're in the position of, if that peace officer observes the person acting in such a way that they reasonably expect this is a person with a mental illness and liable to cause harm to themselves or others, they can take that person into protective custody for an evaluation.
Exactly.
Okay, is Common Ground the only mental health facility that OCHN uses? And I'm guessing they mean for the AOT process.
Well, I'm not sure what the person is going for with that question. While we do some supervision of the AOT process, it is primarily monitored through the individual CPAs, Easter Seals, TTI, and CNS. They are always welcome to confer with me or with OCHN if they have any questions or concerns.
Okay, we have another question. If a person is in jail and doesn't have any family and isn't compliant with treatment, can the jail caseworker file a petition? And if they don't, and the person is released, is there anything that could happen to assist the individual? Melissa, do you want to unmute for clarification?
Yeah, I was just wondering, because I know that there's people in the jail that are not compliant, and of course there's those people that don't have families or any contacts outside of the jail. And I wasn't sure if the jail caseworkers are allowed to file the petitions, or if they don't file the petitions once the individual's released, is there anything that can be done?
I can't think of a reason that a petition couldn't be filed.
I've never seen a petition from a jail.
You haven't?
No. I've had parents come in that their child's in jail, trying to get them out of jail and to be evaluated, transported over to be evaluated, tried to get them into a hospital. I've only seen that work twice, and both times it was because the district court judge allowed them to be released from the hospital for mental health treatment.
Okay.
But normally, because the jail has mental health services, I realize that you can't force them in jail.
Right.
They do have the
And
services there.
Can I clarify, is this person, Melissa, are you talking about somebody like have the caseworker file a petition while the person's incarcerated or after they're released?
Well, I was wondering for, well, specifically if they're incarcerated, if the jail caseworker could do that. Because I know that that situation has happened where there's people that are not compliant,
Oh,
that they denied treatment within the jail, but have significant mental health issues. And so I wasn't sure if the jail caseworker could then file a petition.
Well, a probate judge can't trump a criminal judge. So if a district court judge, circuit court judge has ordered someone to prison or jail, a probate judge can't say, okay, my order is going to let them out to get mental health treatment. So it would have to be some kind of coordinated effort between whatever judge has them in jail and the probate court. Like I said, that's only happened a couple times since I've been here. So,
But I'm saying even for once they get released, for that they have to be compliant.
I'm sorry, I didn't catch that.
Oh, I'm saying for once, for like the person's going to be released from jail. So can, for that, once they're released, they would, be required to be compliant. So can the petition be filed by the jail caseworker because the person's being released is kind of what I meant.
I mean, I don't see why not. I mean, the statute says any individual over 18 can file a petition if they think someone needs mental health treatment.
Okay.
The tricky part, Melissa, is going to be making sure someone will testify because it's got to be, that's going to be the tricky part, is that jail psychiatrist is going to have to testify. So that's where you might find a barrier.
Okay.
And the petitioner has to have personal knowledge for them to come.
Right. Okay. And that's why I think so many people are getting released and then, on the street.
Right.
Okay. Well, thank you.
Oh, okay.
Megan and Barb, can I ask a follow-up question to that?
Yeah.
Barb, so I'm glad Melissa asked that because I sometimes have individuals, their family calls me or their parents call me and they're in the jail, but it looks like they might be getting released, like Melissa said. So, so they can, let's say the individual's already open with like Easter seals or CNS or TTI. Can the parent or the family member file that petition while they're in jail? And then they can use like testimony from like their already open provider, their psychiatrist?
Well, I mean, I've had that situation too. So say the parents come in, they're worried their kid's going to get let out of jail. Actually, say they're worried about some kind of violent behavior. So they'll come to court and get a transport order in anticipation of them getting out. So what will happen is normally what happens is they come in, they file a mental health petition, they get an order of transport. So if the person comes to the home and starts acting in a way that makes them feel unsafe, they can call the police and have them transported for an evaluation. And then once they're there, then it would start the whole process of the evaluation. Do they need to go to a hospital? Do they need mental health treatment? And that's kind of the only time I've seen that happen, when they're in jail getting ready to be discharged or let go.
Okay. Because I feel like sometimes what will happen is parents will call me and that exact thing happens. They'll be like, well, they're going to get out of jail in, let's say, 10 days or whatever, their next court hearing, and they're already open with like Easter seals. So can we just, have the Easter seals, like utilize the testimony from the Easter seals psychiatrist and like have the provider or the parent file a petition? So you're saying, yes, they potentially can.
Sure.
Okay.
Yeah, I see the answer is yes too, but Barb, does it also raise a question about how long has it been since that psychiatrist has seen the individual?
Oh, sure. I mean, if they're going to provide testimony and the judge may question them about when did you see him last, they say, 9 months ago, I'm not sure how valid that testimony is going to be.
Is
Okay,
there
thank
any
you.
kind of a cutoff line or?
Not as far as I know. I mean, I don't know if like a red letter line, you have to have seen them within the last 2 weeks. I mean, I know we ask about a 2 week. when they're
Okay,
willing
because
to
I know
transfer.
there at least used to be language about a recent evaluation, but nobody wanted to say what recent means.
Exactly. No one wanted to define it. So I guess it depends on the kind of information they can give and what kind of testimony they can provide, and the judge will decide if whether or not it's enough.
Okay, we'll go on to the next question. What are the most common errors you see on petitions that are filed? And what type of errors could result in a petition being dismissed?
I always
Um,
tell people, read the form over before you start writing on it. Otherwise, the two things I see most often are people are starting to write the street address where the name of the county is supposed to be, or they put their name where the subject of the petition is supposed to be.
And I think that's real good advice. I mean, just so you know, it's not like if they come and fill it out, because a lot of times, if it's a transport anyways, they're going to come in and file it in person. My staff will tell them what they need to fix. If they're faxed in or emailed in, you're right, we'd have to send it back and get it fixed. And that's probably the most common mistakes are putting things in the wrong spot or missing the line. So you want to make sure you complete every line there to the best of your knowledge.
Next question is, can you explain how the deferral process works?
Yeah. When a petition and 2 certificates have been filed with the probate court by the hospital, an attorney will be notified. That attorney will interview the patient, might be in person, might be over the phone, might be virtual, and explain that person's rights. One of the rights is you can defer the hearing. Now, what this means is that you can sign a document that says you're agreeing to treatment, and there should be some description in that document about what that treatment includes. And then you're supposed to really sign it in the presence of hospital staff, the attorney, and a CMH representative. We generally aren't able to get all those people together at the same time. But then once that is signed, that is sent to the court. So the scheduled hearing is canceled. And then as long as the hospital is satisfied that the subject of the petition is cooperating with treatment and the subject of the petition is satisfied that the hospital is meeting their needs and they're willing to stay and continue with treatment, then there would be no hearing. However, should one party or the other be dissatisfied, then they can demand a hearing. Maybe the hospital is saying, well, you're not taking the medication that you said you'd take, or the patient is saying, I think I've been here long enough. I've gotten the treatment I need. You said you were going to release me in a week. It's been almost 2. I'm still here. I want that hearing rescheduled. Deferring is not technically the same thing as signing voluntary, but it's more of a formality of a difference. Technically, you are still involuntary when you defer.
And I will add, it's on our list to address the issue of not having CMH representation at these referral conferences. So we are aware of the issue. It's definitely something that's a high priority for me, that I've, made people aware. So that's on our list. So hopefully that will change at some point. For the sake of time, I'm just going to bounce to the evaluation. It was put in the chat, and feel free to use this QR code. It does need to be done. It will be open until 5 p.m. for you to be able to get your CEU. If you have, we'll still get through these questions. Mac and Barb, do you guys have just a few more minutes?
Sure.
Sure.
Okay, so we'll go through the questions, but if you have to hop off, we completely understand for the sake of time. So for the next question, we have, does the hearing proceed if the person in question does not attend the hearing when seeking an outpatient order? And then I'll get to the next question.
Yes.
Well, It probably will. The judge will probably ask some questions about what efforts were made to notify this person of the hearing. How did the person respond to those efforts? And the judge could determine that a good faith effort was made to notify the person, and they chose to not attend the hearing. And in that case, the judge could proceed. Or the
The next
judge could
Or,
Or the judge could decide the opposite. No, it doesn't sound like a good faith effort was made, so we'll adjourn and give them more time to reply.
Thanks, guys. And the next part of our question is, who is responsible for obtaining a provider for an additional evaluation when requested?
You are, Megan.
So I guess that's what I'm trying to understand. I don't know if you're still here, Janelle. Are you talking about can you maybe explain that a little bit more so I understand exactly what you're asking?
Yeah, absolutely. Can you guys hear me?
Yeah.
I was inquiring about, there was a mentioning of the person in question being able to request an additional evaluation. Because obviously the psychiatrist would do or present on what they were able to evaluate. So I was curious who is responsible when the patient makes that request. Is that something that the hospital does, or the CMH, or the court themselves? Who ultimately finds the person able to do the additional evaluation?
I mean, the attorney that's representing the patient, they're the ones that actually have to file a form asking for an evaluation. We can give them a list of names if they don't know anybody. They are people that are usually routinely used by the court, but they would be not the two, clinical cert people. But the court often, there's a court order for it, and then we would pay for the evaluation.
So primarily the attorney representing the respondent.
Correct. They're the ones that make the request.
Thanks, guys. Did that answer? Okay, perfect. We do have, I know, obviously 911 is an option, but Jill did bring up 988. So that is another good option for you guys to utilize. They can help after hours and help, solve emergent needs. And then we have Heather also added, it can potentially help de-escalate the individual depending on the situation. Next question, or no, not a question. Looks like Haley had mentioned, I've seen a few petitions filed from Wayne County Jail. In those scenarios, the jail is usually filling them out to be able to administer medications while the person is there. So that's, I don't know, that's something to watch out for. I don't think that's happening here. But that's something to keep in mind. All right. And then it looks like we just have a client's family once told police that they could leave their home if an individual was making them feel unsafe, as that was their address on their license too. So he was not living there and had SUD and mental health concerns. What could they have done? Oh my gosh, I'm sorry. What could they have done to have the person removed from the home?
The parents said that they could leave, or the police suggested to the parents that they could leave?
The police suggested to the parents.
And I'm sorry, and what's the question?
So the client was being threatening, and their family called police. The police said the family could leave. So I wanted to know how to get the threatening person to leave when they're having a mental health episode.
I mean, obviously there would be 911, or they can come to court and get a PPO, but a PPO is just a piece of paper. So it doesn't mean the person's going to follow
Did the police actually come to the home?
The police came to the home and told the family to leave if they felt unsafe. They did not make the individual leave because his address, was still on his license, the family's home, even though he wasn't living there. Does that make sense?
I mean,
it does, because they're saying that's still his legal residence. But,
right.
I mean, if they're feeling threatened, though, I mean, the police, you would think, would have removed him.
Right.
They have to observe something before they can take action without a court order.
Okay. So
actually, the other thing I would, sorry, go ahead.
Go ahead.
I was just going to add, you can also, I mean, we have co-responders. So depending on the, the time of day, family members can, if they have make a call, they can request a co-responder if we have one in that community, or they can specifically ask for a CIT trained officer. So those are at least, gives you some more options. We can't guarantee that, every city has that here in Oakland County, but it's worth mentioning when they call, hey, is there a co-responder? Hey, can I have a CIT trained officer too?
Absolutely.
Okay. And what was the other word you said? CIT trained officer and
A co-responder.
co-responder.
So we have several co-responders now who actually ride with different cities here. I wish Jody, can you guys I don't remember all of the cities. Who's ever
I'm here.
on?
I'm here. Twyla's here.
Perfect. Can you let them know? Because I can't remember all of them.
We have co-responders in Bloomfield Township, Birmingham, Auburn Hills, Rochester, Rochester Hills, Troy, and Pontiac, and very soon Waterford. I think Ken's here too. Ken's our Troy
I'm here.
co-responder.
So that's an option too. Thanks, Twyla.
Thank you.
You're welcome.
Okay, it looks like the form link isn't working. Hold on, let me text it. When I click it, it works.
It just took a second for me. I don't know if it's just taking a little longer for anyone else, but it took about 30 seconds to open.
Mary, let us know if you're still having issues. Looks like we have, in my experience, the lawyers show up whenever they want for those conferences. Jill, you're talking about,
We have similar experiences.
Yeah. Mac, you and I have worked on several of those together, I am sure, right? Mm-hmm. Where they show up at 6 p.m. at night, they can show up whenever they want, and the hospital has to let them see them. So that's a hard, I don't envy your task of trying to get that all coordinated. Whoever said they were doing that. That's going to be hard.
Now that's the hospitals.
Yeah, well, now that we're doing so many things virtual anyway, they are actually better at least contacting the hospital when they said they would.
That's good. That's good.
When I was a practicing lawyer, I would get these assignments, and there were some hospitals that would actually schedule your deferral conference. And you would call them and say, I have a court hearing that time. I can't be there then. And you're right. We tried to be there within the time, the normal hospital, but sometimes you get them so late, you have no choice. And I don't mean to be defending the lawyers, but that was when we were doing it in person too. We had to go to the hospital and visit them. There's no reason if they're doing virtual, they can't be coordinating with the people at the hospital. So
that's the way I see it.
Lawyers have gotten very entitled, unfortunately, thinking that they can come and do whatever they want whenever they want. So I don't see any issue with a pushback on, come on, you can't be, there's nobody here because you're required to have somebody at the hospital there with them during that conference. So, unfortunately, I think they've just gotten thinking they can do whenever they can, but I agree with Mac. They need to be doing a better job at contacting the hospitals and trying to make arrangements because that's what the statute requires.
Some are better than others.
I'm sure.
Okay. It used to be at Clinton Valley Center that if everybody wasn't together within 15 minutes either way of the scheduled deferment meeting time, then the hospital would just say, okay, we were here, you weren't, the deferment is off. The attorney can still talk to his client or her client, of course, but can't defer.
That's not even close to legal.
Well, they
did.
They
can't do that. But anyways.
They got torn down.
I'm sure. Yeah.
And that may not be the only reason.
We did, Heather mentioned that it's the second link. So those who are still having issues, feel free to use the second link, it looks like, for the evaluation. But looks like there's no other questions. So thank you guys. We will be sending out the PowerPoint after this that has all of our contact information. So feel free to reach out if you guys have any further questions. And thank you for coming today. Mac and Barb, just hop on, just stay on for just a minute. Okay, guys?